Welcome everybody, Jeremy Jackson here again for tonight's video. Well, it's night here. I don't know about what time you're watching this. Um, we got some goodies here today. It took me a little bit of time, but I got to download some documents here that I'll pull up on the screen for you guys to see. I'm getting dangerous with this video stuff. Sorry if the music's on. I got Bob Seger playing in the background. I love me some Seger. Classic rock all the way, I guess that's what I say anyhow. Uh, So yeah, I got a lot of stuff here we can go over. Some of it we've gone over before, but now I got the documents here that'll you guys can see how everything's put together. I'm gonna try to keep it as short as possible without going too long, because everybody knows, nobody wants to have a 2 hour long video to watch, but this is a good one. Let's get started here. The first document I have is defendant's exhibit fraud upon the court evidence packet. So that's what all I have loaded up here. I did leave some things out that I didn't want to put in here for tonight's video, um, but all these are things that I have here. So exhibit A is absence of proofs of service equals void orders by law. So as I said before, um, they very well may have served me. I don't honestly remember. It was 2016, the original child support orders. Again, by law, if it's not on the court history record or the Pacey's record, then it did not happen. Just like if you have a lawsuit going, you're suing somebody, and you don't file the proof of service on there, that other party can come back and say, I want this dismissed because there's no proof of service, and the judge is obligated to terminate that lawsuit because you didn't file that. Same goes for these people. They cannot get away with it just because it's a entity of the court. So that's Exhibit A. We're going to go through most of these. Exhibit B is conflict of interest. Evidence showing Judge Michelle G. Benoni presided over the case, my case, while her husband, Attorney Eric Benoni, represented me, the defendant, in custody and support case. This constitutes a direct violation of Canon 2.11 Alpha of the Pennsylvania Code of Judicial Conduct, and establishes fraud upon the court. So that's a pretty serious thing, and I'm going to show you guys the actual evidence of this, and this ain't just me talking here. Exhibit C, support order, complaint withdrawn, dismissed, officials Pacey's record. We have that in here. We're going to show you that as well. Pacey's official entry, April 18th, 2016, states final order, complaint withdrawn, dismissed. Yeah. And, it proves the case was illegally terminated, making all subsequent enforcement actions void ab initio, which means void from the beginning. And we're going to get into all this good stuff here. Let's see, what else do we got? Exhibit D, evidence tampering, lack of Title 4D application, void jurisdiction, and demand for criminal investigation. This is a pretty serious one. I have some things in here for this exhibit, but like I said, some things I'm not going to put on here. Some things are better kept private and to await trial. So to break it down, it's a sworn affidavit by me documenting fraudulent alterations, absences of a Title 4D application that's required by federal law and state law, but 42 USC subsection 654 and 45 CFR 302.33. And April 8th, 2016, Pacey dismissal request, referral to the district attorney and attorney general for criminal investigation under 18 Pennsylvania CS subsection 4911. So that means you're enforcing an order that is void, that is null, that is closed, and you're still enforcing orders on me. Again, I'm going to remind you guys, they just took a lien out on me for $6,000 when I sold my home the end of last month. That's also a big problem, because we actually got proof here that this child support order has been withdrawn, dismissed, and withdrawn, and that should have been the end of that. Nothing else should have happened after that, and that was back in 2016. So this is the problem I'm having. How are you guys? How is child support, domestic relations allowed to enforce anything on me? They took, like I said before, they even just took that lien for $6,000 without notice and without a hearing. That is a direct violation of due process rights. Um, I'm supposed to be able to have the right to either dispute it or pay it or whatever it may be, or to have a hearing over it before they take any kind of funds from me. So we got two serious violations here. The case is technically legally closed because it's in an entry by a judge. In the Pacey's docket, it was never reopened. So you took money from somebody that don't even technically have a case with you. So you guys see what I'm getting at here. Might have to watch this video again, but you have to really listen to what I'm saying. Next thing here is Exhibit E, certified records picked up by me on September 8th. I went up there, I demanded all of my documents the child support domestic relations ever had that was from me or for me, anything involving me. From my daughter's case, which she's now 21, 22, so she's aged out and that case is closed, as well as the current case for my two sons. I demanded every piece of paperwork that they ever had involving my case. And when I got those piles of papers, there was a lot missing that they did not give. And part of that was the initial child support complaint form, which they are trying to now pass off as a Title 4D application, which it is not. They added 4 more papers with redacted information on it that never existed before. I've never seen those papers, and they try to claim, well, it's because it has private information on it. And so what? You redacted it. So what does it matter? When I asked for all those documents, they should have legally given them to me, and they didn't. They withheld them. Oh, and I want to show you guys something else, so hold on. Where is it here? I just got this from domestic relations. So I'm not going to get sidetracked here, but I was just telling you guys I demanded all my documents. Well, in those documents, there is a Pennsylvania Child Support Enforcement System, the Pacey's, payment history report. So when I got the payment history report, it went from 2019 until 2025. They are missing 3 years from 2016 when the case opened up until 2018. And guess what they did? I caught it, and they just sent it to me. That's what this is. This is the missing. This is the missing 3 years of payments here. So they're piecemealing me things that I've legally should have had all when I asked for it. I don't know why they feel the need to do whatever they want. Well, I'm not going to allow that shit to happen no more. That's done. So on to the next page here. This is page number 2 of what all evidence we got here tonight to show you guys. I hope you guys can see this all okay. I don't want to screw it up in any way, shape, or form for everybody here. Let me see if I can make it any bigger. Yeah, I don't want to make it too big without cutting it off. Okay, so Exhibit F. This is about attorney Emily Geiger. She is the domestic relations Title 4D attorney. Her filing. Okay, so this Exhibit F here is talking about. I filed a motion to have my child support case terminated and vacated because of all the reasons that we're going over here. My main reason was there was no Title 4D application, and there still is not as far as I'm concerned and by law. What they have is a generic child support complaint form. And we're going to get to all that, what makes it illegal and not a Title 4D application. But anyhow, when I filed that motions hearing, Attorney Emily Geiger filed back her opposition to me filing this hearing. And in this opposition, this is when they finally added, like I said, the original child support complaint was 4 pages that I seen, generic, barely any information on it. Now she introduces 4 more pages, the redacted pages I told you about. She adds those into her opposition of me filing a motions hearing. It's kind of funny, you know. You bring up something, they don't know what you're talking about, and I'm going to show you guys transcripts of her saying we don't have no Title 4D application that we would have anybody sign, a plaintiff or defendant and all that stuff. So now all of a sudden, afterwards, they pull up these extra 4 documents that are redacted, you know, like I don't know the information of my ex, you know. So we'll get over that. Here, Exhibit G, transcripts of Attorney Emily Geiger, all the stuff she said, contradicting herself. We got that. Exhibit H, I didn't put these in this packet here, but I do have them. Exhibit H, I sent right to know requests to the Pennsylvania Department of Human Services, DHS, and I demanded them to give me a copy of the valid Title 4D application signed by my ex to the Domestic Relations Office that can actually is the foundation of a Title 4D contract and case. And they actually sent back, there is no 4D application on file to give you. Twice they answered me. And this agency, by law, is supposed to have a copy of the valid Title 4D application. They are supposed to be the second agency that is supposed to have a copy of this for record keeping and the incentives that domestic relations get through the federal government. So they even said, no, we don't have nothing we can send you, Mr. Jackson. Sorry. And I have those documents from here, but there's no point in pulling them in because that's pretty much all it says. And Exhibit I, full disclosure and informed consent. I didn't add that in here. But what that is, it's a paper that just happened to come out. It's hard to explain. It was in the packet of papers that Domestic Relations gave me when I demanded all my papers. But the funny thing is, there is, at the bottom of the page, there is sections 1, 2, and 3. And then somebody hand wrote number 4 and then put submitted to our jurisdiction. And what did I file for? A motion to vacate due to no jurisdiction because the case is closed. They don't have proof of service, blah, 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 blah. So I find that very interesting that somebody happened to just write submitted to our jurisdiction after I brought up the fact that they don't have jurisdiction over me or my case. So this is the kind of stuff these people are playing here, you guys, and you know, this is serious stuff, and they think they're getting away with it, but it's not going to happen. So I'm going to blow this up so we can see the bottom part here. The summary statement: absence of service. We talked about conflict of interest with Judge Benoni and her husband on my case at the same time. Pacey's dismissal, we talked about that. That's where the original child support complaint order was terminated and dismissed and withdrawn. Fraudulent additions, those are the documents I said that were never around until I started causing a stink about some things and asking questions. Why aren't these things here or available? Why has nobody given them to me? I've been asking for a Title 4D application since April of 2025, and just finally in August, I believe it was, in August, they came up with a child support complaint form, not even a Title 4D application. So yeah, they think they're good, but they're not that good. And if you're watching, I got you. Let's see what's next. Contradictory testimony. That's what we talked about with their domestic relations attorney, saying things such as there is no 4D application that I know of. We would never enter into a contract with either a plaintiff or defendant, blah, 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 and spinning words like they do, like she does. Sometimes I think, the lawyers taught this, or is this just a natural God-given right to be a blithering idiot, and liar, And then we got the DHS confirmation, which we talked about. That's the two papers that Department of Human Services said, no, we don't have no Title 4D case. Yeah, let's see what we got here. Oh, then we have fabricated alteration. That's the one I was telling you about, where they added submitting to our jurisdiction on part of the form that is not the official form itself, that is an addition on there that they should not have added onto it, and a pattern of concealment. Everything together that I've asked for, all my documents, there were so many things left out, things missing. Again, when I asked for a 4D application, they brought up a complaint, and then I started bringing more things up about it. Well, that's not a 4D application. That's a generic complaint that don't have the proper information on it. And then a few weeks later comes these extra 4 redacted papers. So that's no good. That's concealing, and there's a reason why they do that. Okay, so what are we going to go on next here? Let's see. Evidence summary sheet. Okay. This is a good one here. So don't worry about it if I make this big so you guys can see. I might be blacked out of the way, but nobody wants to see my ugly mug anyhow. So no Title 4D application. Federal law 42 U.S.C. subsection 654 and 45 CFR subsection 302.33 requires a signed application for Title 4D cases. Pennsylvania Department of Human Services confirmed in writing 2 times no 4D application exists. Attorney Emily Geiger also admitted none could be produced. Without it, the court lacks statutory authority. Number 2, Pacey's record omission. The IF 521 form, that's the form we talked about where somebody hand wrote in there, submitted to our jurisdiction. That's what this form is called, and that's what it's talking about. That's tampering with legal documents. When you handwrite things on a legal document, you're making additions to it. You're not allowed to do that. I'm not allowed to do it. You're not allowed to do it. They're not allowed to do it. The court's not allowed to do it. Nobody's allowed to alter a official document. You can't do it. It's against the law. But they get away with it, I guess, up until now, because I'm not going to let it go. Now we're going to get into some actual evidence, good stuff here. This document that I'm showing you guys, this is actually part of the my Pennsylvania Pacey's docket history report. You see the third one down, it's highlighted here. These are all entries, and there's pages and pages and pages of these. From 2016 up until today, well, whenever I pulled these papers. If you can see right here, final order. Complaint withdrawn, dismissed. On 4/8/2016. Yeah, the case was open. My ex filed for child support on January 26, 2016. So this was literally 3 months after it was open. Somebody put a final order in there. A complaint has been withdrawn and dismissed. There it is, guys. I'm going to show you guys also the law that states that this document right here that I'm showing you guys, this whole document is binded by law. Like, this is an official record, and it has to be kept up to date and current and correct. And whatever is on this record goes. There are laws for that, and that's what this is, guys. Look at it. The third entry down, it's highlighted. What does that say? Final order, the complaint. Again, which is a child support complaint. That's what they call it. That's what it is. It's not a Title 4D application. It is a generic child support complaint. And it has been withdrawn and dismissed back in April 2016, guys. There you have it, right there. That's evidence. Next, we're going to get into the Judge Benoni was the judge on my case. And at one point, her husband, which is a lawyer across the street from the courthouse, represented me. And again, like I said, I don't even think I knew who my judge was back then. I was looking for a lawyer that was somebody that was close to the courthouse, and there it was, so that's who I got. But you would think that knowing that the lawyer knows who the judge is on my case. So if you know it's illegal and unethical to take my case knowing your wife is the presiding sitting judge on my case, why would you do that? Simple answer, because they've been doing stuff like this for a long time and nobody's checked them for it. So we're going to get into that. I'm going to show you guys the actual evidence of it. Let me see what we got here. Oh, that was that. Okay, so first we're going to go over things that are wrong with that situation of a judge's lawyer husband representing me in my case. So this is my legal brief. I make these before every piece of evidence when I put it in my evidence binder. So I'm going to scroll up here and enlarge this a little bit for you guys to read. Defendant Jeremy Jackson, proceeding pro se, means I represent myself. I don't want a lawyer. Submits this brief to demonstrate that Judge Michelle G. Benoni presided over and signed orders in defendant's mine support case while her husband, attorney Eric Benoni, simultaneously represented me. This constitutes a direct violation of Pennsylvania's Code of Judicial Conduct and the 14th Amendment's Due Process Clause, rendering the orders void ab initio. Ab initio means from the beginning, just so everybody knows when you see that. Statement of facts. On November 3rd, 2016, attorney Eric Benoni entered his appearance on behalf of me as confirmed by his signed letter to opposing counsel, blah, blah, blah. November 4th, 2016, Judge Michelle Benoni, the spouse of Eric Benoni, attorney Eric Benoni, signed an order of court in the same matter, my docket number, my Pacey's number. The signed order bears Judge Michelle G. Benoni's signature directly below the printed title by the court. At that time, the order was issued. Attorney Eric Benoni was counsel of record for me. Judge Benoni did not recuse herself and continued to preside over this matter despite the clear conflict of interest. Hang on, I'm going to blow this up some more. Now, here's the governing rules and laws for this stuff, guys. Pennsylvania Code of Judicial Conduct, Rule 2.11, Alpha 2. A judge shall disqualify herself in any proceeding in which the judge's spouse is acting as a lawyer in the proceeding. Judicial recusal is not optional. It is mandatory when a spouse is counsel of record. B. Constitutional due process. 14th Amendment guarantees litigants the right to an impartial tribunal. Caperton versus A.T. Massey Coal Company, 556 U.S. 868, 2009. Those are cases. Those are case laws. You guys can look those up. Due process is violated when circumstances create a serious risk of actual bias, even absent proof of actual prejudice. So what that means is it doesn't look good on them. It just doesn't look good on a husband and a wife on opposing sides. You know what I mean? Like it's no good. It's bullshit, to be honest with you. C. Void orders. An order entered by a judge who is required to recuse herself is voidable and subject to collateral attack. In R.E. Murchison 349 U.S. 133 136 1955, our system of law has always endeavored to prevent even the probability of unfairness. So if it looks unfair, if it may be unfair, if there's a slight chance that could be unfair, they should be recused and move on and be done with it and assign it to somebody else. That's what that means. The rest of this document I just showed you, or I just had up here, this is the remaining second page of that. Judge Michelle Benoni's spouse, Eric Attorney, was defendant's counsel at the record time she signed the November 4th, 2016 order. Pursuant to Rule 2.11 Alpha 2, Judge Benoni was required to recuse herself. Her failure to do so constitutes judicial misconduct and denial of defendant's due process rights. The November 4th, 2016 order and any related actions taken under Judge Benoni while Eric Benoni represented me are void from the beginning and unenforceable. So the conclusion of this is the conflict of interest arising from Judge Benoni presiding over my case while her husband, attorney Eric Benoni, represented me is a clear violation of judicial ethics and constitutional guarantees and impartial justice. Defendant respectfully submits that all orders issued under these circumstances must be vacated as void. That is, evidence further supports claims of systemic corruption and fraud upon the court. Guys, I've been telling you this for months now, that this all started when they took my sons off me. And since they did that, all I've been doing is this: studying, learning, finding things out, digging, getting the dirt on everybody. You can do it to me, you know. You guys can dig up whatever you want on me. I admit I was never a person, but I don't have no felonies. I don't touch kids. I don't harm people. I don't do drugs. I don't deal drugs. I don't do nothing. The worst things I ever did was when I was young, was underage drinking. Every time I would go drinking, I would get caught. I swear, it was a gift I had. You know, when people would see me coming to a field party, they'd all just take off running and be like, "Oh no, he's bad luck. You know, there he is. Get him out of here." So I don't really have much to hide. I wouldn't be doing all this if I figured I'd have something to be attacked for. I serve my country honorably. I have my children. I love them no matter what they think or their other side of the family tells them or what they hear. I know I never hurt them. They're the world to me, and they still are, no matter what. And, you know, I hope one day they will see all these videos and all the effort that I put in, because they were taken from me by a bullshit story that I was cleared from, no less, needless to say. So here's the actual evidence of Benoni causing a conflict of interest in doing that. This is the first page. This is just a cover page for my case and for whatever hearing that I had to go to. Now here's the gold right here, guys. This is the actual order signed by Judge Benoni, right here at the top. You guys can see, it's like somewhere over here, yeah. It says right by the court, and then below it is Judge Michelle Benoni's signature, and right below her signature is her husband, Eric Benoni's signature. It's a court order, guys. That's it, right there. That's right there is what you called an exhibit, in evidence. This is just one. This is just one thing of hundreds of violations that this court has committed, and these people in this court. It is just sickening, unbelievable, and they still have the nerve to come after me and threaten me with jail and all this other shit. You got to be out of your mind. So when you do that to me, I'm just gonna come for you. And when I say that, I mean I'm gonna do this every day. I'm gonna make videos. I'm gonna show everything. I'm gonna start putting it out there for everybody to see. Again, here's this is a letter from the attorney's law company to my ex's former attorney. Just another piece of evidence showing what's going on here. So next I got some transcripts from a motion hearing. We was talking about the Title 4D application and all that that I never had proof of. The domestic relations attorney, Emily Geiger, said don't exist. Now they say it does exist. So I'm going to go through these with you guys. This is the first page of the transcripts. This is, and again, I did not add every single page to the transcript, and some people might say, well, that's not fair. And I get it, but we're not on trial here. I do have the whole transcripts, but I did want to show you guys the valuable parts of these. So this is just a cover sheet for the transcript. Shows when the date was, who the judge was, who was the plaintiff, who was the defendant, blah, 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 who was involved. Now, these pages here are a little bit numbered differently, so give me a second to pull them up. I'm going to try to pull them up in order here the best as I can. So, okay, looks like the first page is going to be page 6. Okay, sorry guys, I got a kink in my neck. I don't know why. Maybe all this paperwork and all this corruption is finally getting to me. So, alright, we can get to the highlight part here. I'm going to make it bigger. So, let's see, I asked her, where it says Mr. Jackson, obviously that's me. It says the court right above it, that means the judge. And then it'll say Ms. Geiger, which is the domestic relations 4D attorney. So, let's see. I asked her if my case was Title 4D. Okay, so the domestic relations supervisor, Jacqueline Henry, I had a conference with her. I told you guys this before where I took notes, and she told me that my ex is not receiving 4D money. So when somebody tells you your ex is not receiving 4D money, does that mean that your case is not Title 4D? Because that's what I took it as. I don't know who else would. So I said, was my case Title 4D or not? She said no, and pulled up a screen when I was in her office and pointed at some charts that say, see the state here, the state there, you don't know none of this, you don't know none of that. And it states that I went down there today, and she said it is a Title 4D case. And then I emailed her after that conference asking her, I said, you did say my case was not 4D, right? And then she changed her story and said, yes, your case is 4D. So, again, this goes back to why you're not allowed to record in courtrooms or courthouses or domestic relations offices, because you would catch them in lies every other word that comes out of their mouth. So that's what happens. That was page 6. We got page 7 here. Let's see. This is me talking. I don't know how my ex is entitled to the Title 4D process. I'm sorry, grant. I didn't know you had to pay a grant back, because that's basically what Title 4D is. It's a grant given to domestic relations and the ex. It's given to domestic relations. The payor of child support, which is me, must pay domestic relations back. And they get their money back through incentives and all. It's just a bunch of, it's all about money. That's all it is. So Ms. Geiger says, I think I can clarify that. We did receive, oh, this is another good one here. So I sent a bunch of documents, a bunch of legal notices requiring answers and replies to the domestic relations office throughout a long period of time, and they never responded to me. So, Ms. Geiger, we did receive numerous filings from Mr. Jackson in our office. In fact, I have a stack of them here. I'm not sure if what I brought with me is comprehensive of what's in the docket, but he has filed numerous times in numerous different documents with our office. None of them, some of them did require a response. 99% of them required a response, just so you guys know. But it's not our office's policy to respond to those documents. That is a violation of due process, the right to be heard. And she stated it right there. There it is. Clear evidence of violation of due process. But we do not respond to them. It's right there. And she says the Title 4D issues that he's referring to is the Title 4D of the Social Security Act. That is where our office gets its funding. And all child support cases are Title 4D cases. And we're going to come back to that in a little bit. No, they are not all Title 4D cases, and I'm going to show you guys that. So remember that when I bring it up. Let's see, that's 6, 7, page 8. The only cases we have that would not be Title 4D would be spousal support alimony cases. And the judge says, right. Ms. Geiger says, Ms. Henry did discuss this with Mr. Jackson. She indicated to him that his case is not a TANF case. No. I'm going to stop you right there. She did not tell me it was a non-TANF case. I already knew that. I asked if it was a Title 4D case. So this is what they do. They manipulate and they try to move words around and put words in your mouth that you never said. So let's see. TANF case, which means that nobody on the case is receiving welfare. So I think that there's the distinction there that maybe was misunderstood. No, no, Ms. Geiger. I was not misunderstood. Nothing. I think you guys are intentionally misunderstanding me because I caught you in a lie. So what it was is I was asking for a Title 4D application and asking about the 4D process. They don't like it when you ask questions about their 4D grant money and their incentive money and all the other shit. They don't want nothing to do with it. They'll do whatever they can not to talk about it. Why? Well, I know why, but I'm not going to bring that up here. That's for trial. But this case is certainly a Title 4D case. She says right there, this case is certainly a Title 4D case, and all child support cases are 4D cases and proceed through that program. Again, no, they do not. And she's lying to the court. She's lying to me. That's perjury when you lie in a court. I guess it's not perjury if you're a lawyer. Okay, we'll go through a couple more of these. I mean, there's a few of them here that I think are important. So let's see here. Okay. Oh yeah. So pretty much, I was talking about how I took notes at the conference with Jacqueline Henry, the supervisor at Domestic Relations. They're all up in arms about did I record? 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 So if you guys look towards the top here, this is me talking. I had a contempt conference with her, meaning Jackie Henry, a couple months ago. I'm sorry, this is more than a few months ago. It was probably April. Miss Geiger says, she jumps in right away, which are not recorded, Your Honor. Those are not on the record. Well, because I made my own transcripts, does that mean that it didn't happen or I'm lying or they don't count? You know, I mean, you can't record in there. What else are you supposed to do? Write it down, make your own transcripts. So that's what I did. And they still worried about it recording. And then, then the judge jumps in. So you did not record. You didn't record anything in that hearing. If you look above, right above where he starts saying that, I state, no, I took notes. I took notes for it all to work right. And that's why I have the transcripts that I made. I made them, but I don't have any other way to prove that since I can't record. I have to take notes. And then again, ask me. So you didn't record. You didn't record anything in that hearing. They're looking. They're just looking to find something to jam me up on so they can shut me up and toss away the key. That's what they want to do, but I'm not going to give them the satisfaction. They didn't record nothing. People do take notes. People do take notes that are allowed to take notes. People are organized. Like me, I'm organized. I do things like that when it involves this case because this is my life. This isn't just some game I'm playing. This is my life. My kids are taken from me. Now I'm fighting for my life against a corrupt family court system, and I'm not going to stop. So that's why I'm doing all this. And I'm sorry this video is probably getting out of control with the length, so I'm going to speed it up here a little bit. It just goes on saying I did take notes. She did, domestic relations lady did say my ex is not receiving 4D money and that it's just a 4D process. They labeled my case Title 4D, and by law they have to have an application, meaning a Title 4D application signed by the other parent to domestic relations. And again, this attorney here is good at trying to manipulate words. I guess that's just what they do, especially this one. I don't like it. I don't think anybody likes it. Let's see. So I pretty much said to the judge, that court order not being rude doesn't mean anything when it has to do with enforcing child support. Because you label my case a 4D case, and you want to come after me with sanctions, jail time threats, and all that, but you don't have a Title 4D application to show me that it's a valid Title 4D case. So, which is right, and then again, the judge here says, aren't all child support cases 4D? And Ms. Geiger, once again, all child support cases are 4D, Your Honor. And can you imagine if we had every defendant sign a contract that said we would enforce against them? We would never get any money. She said that. She literally said that. She spun her web, and she tried pulling this shit, this Houdini. That's what I was saying. That a defendant would have to sign a Title 4D application, and if a defendant didn't sign it, then they couldn't enforce it. That is asinine to even assume or think that that's what I was saying. But we all know the game here. We all know the game here. That's not what I said. They know what I said. They know what I'm looking for. The 4D application. Um, Again, in all child support cases are not Title 4D, so don't let them fool you. Again, stay tuned because we're coming back to that in a couple minutes here in this video. So the court says, the judge says, my understanding of Title 4D is an agreement between the federal government and the states that provide federal funding to individual counties that have a method for collection of child support. Yes, that's exactly correct. And I said yes, but when you request for proof of that to be legal and to be actually and be enforced, there has to be an application, and there's no other way around that, Your Honor. And I said that very politely, and there's really not another way around that. So, and here's the second part of that. This is right after the one we just looked at here. So now the judge says, hold on, an application for what? And I've been saying this. I said it 5 times in this before he says an application for what. So I state a Title 4D application. And the judge says, between who? Who's the application? Who's the contractor? And I answered, it's between domestic relations and the custodial parent or the parent that is requesting child support. That is who the application is from. I don't know what's so hard to understand that. And then the attorney jumps in saying that would be the complaint. So right there, she called it a complaint because that's what it is. It is a child support complaint. It is a generic complaint. It is not a Title 4D application. It does not have all the required necessary information from a Title 4D application is supposed to have on it. So right here she says it's a complaint. An application for our services would be the complaint filed by the plaintiff. Filed by my ex to get child support. That's what that is. That is not a Title 4D child support case. That is a child support case. And we're going to get to that, what the laws are and why there's not just Title 4D. The judge says, right. And I said, no, Your Honor. They don't have a Title 4D contract, and I don't mean to be rude here, but that's the fact. There is no other way around it. And I said contract, and I should have said application. And then he asks, is there a section or statute that you can refer to that you're relying upon to say there is or needs to be a contract application? And I said, yes, if you give me a second to look. And then I said I found one here, 45 CFR subsection 302.33, which is exactly what it was. And then the domestic relations attorney jumps in, and bear with me, I'm going to blow this up. Okay, so she says that I'm referring to 4A services. I'm sorry, that code that I told the judge is referring to 4A services, and it's not. If you guys turn around and look at that code I just said right before I pulled this from the last picture here, it'll say Title 4D services, and that's what it is. And where I said it says Title 4D and also Title 4D, yes. So I was correct. It was not Title 4A services. She spun that up, tried to make me look like an idiot because I'm representing myself. And if you guys can see the pattern of the judge and the domestic relations attorney bouncing off each other to see what they can do next, and it's a pretty intricate game they're playing. So yes, I looked into it. It is the correct title. Let me see. And I think the last page of the transcripts here, which is very interesting, which I want to show you guys. What it says here, I'm going to blow it up because I think it's good. Bit too much here. Okay, so this is the end of the hearing here going on. Let's see. Miss Geiger says, "Is there a there is a I'm sorry." She says there is a Title 4D cooperative agreement. Again, like I stated, that's between the state and the federal government. And as I was just saying before, guys, um, that's not what I was asking for. I was asking for a Title 4D application between the person wanting child support and domestic relations. They can't prove that. So at the end of this, the judge says, okay, well, I mean, I think there Mr. Jackson raises a lot of points and information that he's provided. What I'm going to do is I'm going to take time under advisement, which he did, and he denied it, even after all the evidence I showed. So I don't get it. I don't know. I hope this thing ain't lagging. I'm sorry, guys. We're going to finish this off here. Got about another 5-6 minutes or so. What I want to go with you guys and show you. Okay. So remember I said about the Title 4D, they're saying that there is only Title 4D applications. What I'm going to show you guys says that no, it's not. We'll get to it here in a second. Transcript excerpts from Emily Geiger saying there is no 4D application. I give Mr. Jackson. That was in the transcripts. In the same proceedings, she also claimed all cases are 4D. Fabricated additions to the record. Let's see. Yeah, she's just talking. We're just talking about there's other pages that were added on afterwards and all that. And then about the Pacey's file record not being accurate, saying the case was closed, no proof of service in it. That's what that is. Okay, so let me see here. Pennsylvania CS subsection 437 alpha requires domestic relations to maintain a complete, accurate, and up-to-date records. The contradictory Pacey's file and missing histories violate this mandate. So these are all the laws here that show you that are broken by them not keeping updated files, things that were not complete, things that were added after, just a bunch of BS. Those are all the laws that show everything is wrong with what they're doing. Let's see. Okay, let's see what else we got here. Oh, here we go. Not all cases are 4D. Here we go, guys. Okay. Pennsylvania law. Federal law. Federal law 4D cases require an application. Tells you right there, you must have an application. So far, they haven't given me one. They've only given me a generic child support complaint form. And these are the laws that show the Title 4D agency must make available child support services established under that after they file an application, a valid 4D application. Pennsylvania law, non-4D cases do exist. 23 PACS subsection 4341 alpha. The obligation of support is enforceable by a complaint filed by the person to whom a duty of support is owed by that person's guardian. 23 Pennsylvania CS subsection 4342 Bravo. The court shall enter an order of support upon petition of a party. So that means if I'm the woman and my ex-husband is my ex, I have the child, I go to the court, file an order of support with the courthouse, the judge signs it, and that's it. And I have to enforce it. So if my ex don't pay me, I have to go up to the judge, tell the judge, hey, she's not paying or he's not paying the child support. We need to have a hearing. They'll schedule a hearing. So that's how it works when it's a non-4D. So non-4D child support cases do exist. It's not some new thing that's just happened. They've always been there. Let's see what else. 23 Pennsylvania CS subsection 4306 Delta. The Department DHS shall be the agency designated as a 4D agency for this Commonwealth, meaning they are supposed to have the valid Title 4D application in their files if it existed. Remember, guys, I told you I sent right to know request demanding proof that a 4D application exists, or send me the actual copy of the application. And they sent me 2 letters back stating there is nothing on file that they could give us. And the final one here is domestic relations section. Shall maintain complete, accurate, up-to-date records on all cases being enforced under Title 4D. They're not. And I showed you guys proof before. And believe me, I have tons, I have stacks of papers showing that it's not up-to-date, complete, and accurate. So again, that's all for trials, hearings, courts, all that stuff that's coming up. Believe me, I got my ducks in a row, guys. I wouldn't be doing none of this stuff. I wouldn't do it if I didn't have my shit together, just say that. So, Figueroa versus Commonwealth, 2983D 1177, PA held that Title 4D enforcement mechanisms like driver's license suspension cannot be applied where statutory prerequisites are not met. Reinforces that Title 4D tolls require a valid 4D case. You don't have a valid 4D application, you don't have a valid case. You don't have valid proof of service documented, you don't have a case. You got judges not assigned to my case, signing orders on my case. You don't have a case. That's invalid and it's illegal. You got a judge with her attorney husband signing orders on my case. Conflict of interest. Orders are void and illegal and unethical and a lot of other things. I can go on and go on and go on. Guys, I'm not just pulling this stuff out of my ass. I'm not making it up. I'm not a know-it-all, but it don't take much to do some digging and find out what laws are and what things have to be what, and that's what I've done. And I'm proud of myself for that. It's a lot of work. It's a lot of boring, not having a life, not having any money. But it's all worth it because I'm doing this for the greater good. I'm doing this to fight to get my children back, and I'm doing this for everybody else down the road in the future that hopefully never has to have this happen to them, because you know what, it's a pretty bad feeling. I'd take war, I'd take combat, I'd take a lot of things over this, you know, not having your sons that you raised since the day they were born and all that taken from you. It's pretty sickening that they allowed this to happen, and this is how far I have to go just to prove that they are doing wrong and that I didn't do nothing wrong. So you know, I think that's about all I'm gonna. Oh, we're gonna. Well, I actually got a couple things here that I think are the last final few minutes here. I nicknamed them kill shots on here, and it doesn't mean anything physical. Nobody's getting shot. Nobody's getting killed. Kill shots mean when you have the solid proof of something that'll destroy a case. That's what I got. So no proof of service. This right here shows you all the laws, all the case laws that back it, of what happens if there's no proof of service on a docket, like a court case history record or the Pacey's record. The effect of not having proof of service, all orders are void ab initio from the beginning. Evidence I have, Pacey's record, no service entries. Certified case history report from the court, no proof of service filed. That's kind of hard to fight whenever it's documented in black and white, and I have those too. Kill shot number 2, complaint withdrawn and dismissed. Yes, everybody, the complaint was withdrawn and dismissed. PARCP 1910.4, complaint initiates support action. PARCP 229, withdraw discontinuance ends action. That means when it says withdrawn, that means there is no more action to take in that order since 2016. So everything they've done to me up from that point up until now is completely illegal, and I'm going to hang them out to dry for it. And you know, the funny thing is, I actually had a meeting with Mr. Kowalski, the director of Westmoreland Domestic Relations, and he says he commends me for what I'm doing, but I'm wrong. Well, Mr. Kowalski, if you think I'm wrong and all my evidence is wrong, I feel bad for you. We could have handled this like grown men. I came to your office about a illegal lien you put on me and asked you to handle it, gave you the evidence that I had, and you laughed it off and didn't take no responsibility for it. And I remember I said that the federal judge is going to probably not take too kindly to that, or we'll let him decide who's wrong and who should be commended for what they did, because it ain't going to be you. Kill shot number 3, unauthorized judges signing orders. Again, I didn't really show you guys many of those, but I probably got about 8 or 9 orders signed by judges that were not on my case, legally assigned to my case. They were not. And that is illegal. Here's the laws for it. Only properly assigned judges have authority. So anybody else that's a judge that signed papers or orders on my case that were not properly assigned, you voided my case by doing that. And I got all those documents to prove it too. So let's see what else. Orders entered without judicial authority are invalid. There's plenty of orders that were signed by other judges. Those will be voided. So pretty much, guys, basically this whole case, everything they've done is going to be voided. And when this gets to federal court or my state court level, as long as that judge that I have for my state suit against domestic relations sees what's happening, which I think I will do a good job presenting that to him. I don't think these people stand a chance. And if for some reason it doesn't go my way, it will be appealed to Superior Court. I will take it all the way up the chain. So that's that. And we got one more page here to go. It's the rest of the kill shots. 4 or 5. Let's see. I'm going to blow it up a little bit for you guys. Sorry, we're at 56 minutes. Long video, but it's very important that I showed this to you guys. Paces inaccuracies, missing entries. So this is something I didn't really get into with you guys yet. But I do have piles of papers from the Pacey's history report. And I do have all the orders, whatever they gave me. And it shows a lot of the orders that I have are not entered on the Pacey's docket, which they're supposed to be. A lot of orders on the Pacey's docket lack actual physical orders. I don't have them. They're not available. Final one, kill shot number 5, is what started this whole train. Is I've been asking for a Title 4D application, and they've never provided me one. Again, they provided me with a 4-page child support complaint form, a generic complaint form, and then later on added 4 more pages that were redacted that just happened to poof out of the sky. They weren't in the documents, request documents that I requested. When you do that, they're supposed to give you everything, and they didn't. You know, it is what it is. I think you guys get the point. But the conclusion here for tonight's video is any one of these kill shots destroys jurisdiction. Together they show a systemic pattern of fraud and due process violations. The prayer for relief here, obviously I want the case terminated. I'm going to get every penny back that they ever took off me, times 3 for punitive damages and treble damages. There's a lot of things that I want for what they've done. And again, folks, like I said, I got every piece of paper to prove it, black and white evidence, and I got black and white law, black law that backs it up. So it's pretty solid. There ain't no way out of it this time. All I got to do is do my job and hope that I do it right. And I think I have. So with that said, and all that evidence and all the fun stuff we talked about tonight, guys, sorry it was such a long video. We're at 59 minutes. I apologize, but thank you for sticking out with me. Again, this is very important. Please share this with everybody. Again, this is to get my case out there. It needs to be public. I'm working on getting at least a reporter from a pretty big Pittsburgh news channel to hopefully take this case of mine here and make it public, because it really needs to be. We need to change the way these family courts are operating and these domestic relations offices. Absolutely. So, thank you guys for your time, and stop by for the next video. Have a good one.